Alphabet's Google and Meta have been found liable in a landmark social media addiction trial.
The jurors in the U.S. ruling that the companies had intentionally designed platforms dangerous for teens and failed to warn consumers about the risks. The case involves a 20-year-old woman who said that she had suffered from depression and suicidal thoughts after becoming addicted to social media as a child.
The tech giants were ordered to pay the plaintiff, known only as Kaylee, $3 million in compensatory damages and an additional $3 million in punitive damages, with Meta on the hook for 70% of that amount. Both Meta and Google say they disagree with the verdict and plan to appeal. Snap and TikTok settled for undisclosed amounts before the trial.
Tonya Waterman reporting for CNA from Washington, D.C., and she explains what's next for Meta and Google.
There's likely to not be any sort of immediate changes, especially since both these companies are likely to appeal this jury ruling. But this is being described as big tech's tobacco moment. So referencing that 1998 landmark settlement against tobacco companies here in the United States who were found to have knowingly hidden the harm of cigarettes. And from that ruling came massive changes and regulations to the tobacco industry. And experts are saying that the same thing could happen now for big tech. They have been shielded for decades by Section 230. This is this law that protects them, these online platforms like YouTube and Instagram and Facebook from being sued or held responsible for the content or comments on their sites. And this lawsuit was quite novel because it didn't go after the content on the site. It went after the design of the websites and what sort of filters they put on their website, which these companies from this jury ruling are in fact responsible for. So this opens the door to new regulation. Much of what is on the books right now in the United States really focuses on things like data collection, cyberbullying, or age verification. And only recently have legislators tried to target addictive feeds that keep these young users hooked on their platforms. So we expect that there's going to be a lot more regulation coming from this. Alphabet and Meta may try to get out ahead of this by putting in some changes themselves, and they have been investing quite heavily to put some safeguards in place in recent years.
Okay, let's speak now to Eric Goldman. He's an associate dean for research and professor at Santa Clara University School of Law. Thank you so much for joining us, Professor. Firstly, I want to get your reaction to the verdict. From a legal and industry perspective, just how significant is this moment?
Yeah, as your reporter mentioned, this is a new ground for the U.S. Having a jury believe that social media services should be liable for their users' harm and assigning a large dollar value to that case is significant. It's a situation that everyone notices.
Professor, I want to ask you a little bit more about this particular approach that was taken by lawyers for the plaintiff, product liability, a defective design. Meta and Google, I guess, return to free speech related aspects of Section 230. I'm wondering why it didn't work this time for the defendants.
The defendants did bring a number of challenges to the plaintiff's claims, including First Amendment claims under the U.S. Constitution and a Section 230 defense. And the First Amendment and Section 230 defenses did eliminate some portions of the case. Those didn't go to the jury, but as your reporter indicated, the court accepted the framing that the plaintiff brought, that the claims were not about the user's content, they were about the choices made and how that user content was presented. All of those questions are going to go up on appeal, and it is not clear that the appellate court will see it the same way that the trial court did. In other words, the trial court's ruling was also itself somewhat novel.
Professor Goldman, what seems to have happened, perhaps has been building as well, is negative sentiment towards social media over the past few years. How much of this came into play as I guess, lawyers for both sides presented their arguments? Is this something that was in some ways inevitable and could lead to a flurry of cases and class action suits as well?
Yeah, across the globe, we've fallen out of love with the internet. Over the last 10 years, consumer attitudes towards the internet have plummeted, and that creates an environment that encourages and rewards regulators who want to dictate how social media services should operate. And it also creates the possibility of jury awards like the one that we saw. Now, the jury was not unanimous. 10 of the jurors said that they wanted to impose liability and damages. Two of them disagreed. And it's a sign that there's still a split of opinion. Is social media net good? We aren't uniformly in agreement, but regulators and plaintiffs' lawyers are proceeding as if social media is categorically bad. It's never good, and they're finding a receptive audience.
Professor, just going back to your point about both how Meta and Google have said that their intent to appeal, how do you expect that to play out, and how likely is it that a higher court upholds or narrows this ruling?
The appeal is going to take likely a couple of years at minimum. So this is a long-term case that's going to continue to have a lot of investment on both the plaintiffs and defendants side. I don't know what's going to happen on appeal. All I know is that there will be a lot of money spent to try and convince the judges to see things their way. And it's a reminder that this case is involving several novel arguments, and those arguments could find receptivity on appellate judges who agree ultimately with this overall negative view about the internet, or it could be completely rejected because it is novel, because it's imposing liability where none should be imposed.
Prof. Goldman, I want to ask you, if you like, about the big picture. What you have said suggests that they are going to spend a lot of time and money fighting the decision. I'm wondering, does that mean it's going to be, I guess, two-track approach from these social media companies? You were talking about this earlier, the fact that everywhere else around the world, the governments have already taken steps to make sure that their minors are protected. So I'm wondering how you see this kind of shaping up, in the months and years ahead on issues, particularly like age verification.
Yeah, to note, the case does not depend upon the minor status of the victim, although certainly we might feel like minors are more at risk of being susceptible to the ploys of social media. The case didn't depend on her status as a minor. And so this distinction between minors and adults, I think, is significant across the globe, but it's not really the issue in this particular case. Now, across the globe, regulators are requiring that internet services identify the age of their users and treat minor users differently. It's an approach I actually call segregate and suppress. The goal is to segregate minors from adults and then suppress resources and content from those minors. In my mind, this is censorship, and this is the kind of thing that should not be permitted here in the U.S. That the First Amendment constitutional protections absolutely should prohibit that kind of approach. So even if things are taking place across the globe, here in the U.S. we might expect a different outcome, and yet regulators across the country are proceeding as if they can regulate every aspect of social media for children, sometimes for adults. And we're going to find out what the Constitution permits.
And Professor, it looks like the verdict seems to have opened the floodgates for similar cases going forward, and the jury has opened the door to punitive damages. I wonder, going forward, what sort of factors will determine whether those are awarded and how significant could they be?
So to clarify, the verdict that came out today was the first of what are intended to be 3 trials, each of them designed to get a sense how well the jury is receiving the arguments of the various sides. In other words, as a result, this was never intended to be the one decision to answer all questions. There's supposed to be 2 other trials that give us more information about how juries view the arguments and what damage they assign. After we get those 3 cases, we might have a better data set of how juries are reacting. So will the next two bellwether trials assign punitive damages? We don't know. We don't know if they'll even assign any damages. They might find that the services are not liable. And so the point of this trial is to give us more information. We got an important and really profound data point today, but it isn't intended to be the end. How much money is at stake? It's impossible to know. It could be that a jury could award many times more than what this particular jury did, or nothing. And so it's been very hard for the parties to calculate a settlement value for this case because of the fact that we just don't know the answer to that question.
Right. Prof. Goldman, I'm wondering if there is a potential silver lining for social media companies because, I mean, to simplify things, if content is not the thing that harms people, it would suggest that the social media companies will not face censorship, not directly in terms of what they put out there, but perhaps in other ways. But is it something that they can use and perhaps, move forward with it?
I really don't think so. And I think that we should understand that if a lawyer or a regulator can say, we're not controlling what you say, but we're controlling how you say it, there's no meaningful difference. That's another form of censorship. The publication decisions include gathering, organizing, and disseminating content. And if the government can regulate any aspect of that, it can control what people are saying. So from my perspective, what the plaintiff's lawyers did in this case was basically make a gambit to the court to accept the idea they weren't going after content, they were going after something else. But that something else is inextricably linked to the content. There's no way to disaggregate them. And that's why I think the ruling is a form of censorship and why all the regulatory interventions are even worse.
Okay, Professor Goldman, thank you very much for your insight today. Eric Goldman, Associate Dean for Research and Professor at Santa Clara University School of Law.